I call the co-leader of the Green Party, James Shaw.
Thank you, Mr. Speaker. Mr. Speaker, I would also like to speak to the Korean tariffs bill. I do want to start by acknowledging the hard work of the negotiating team over a number of years on this. Whether you're for or against it, you can't deny that the New Zealand civil servants who have worked on this have done a terrific job and have worked very, very hard for a number of years. I'd also like to acknowledge Mark Mitchell for the way that he chaired the Select Committee. I came onto the Select Committee just for the process of the hearings and greatly appreciated being given a great deal of airtime to air the concerns of the Green Party and speaking on behalf of many public submitters. Mr. Mitchell chaired the Select Committee in such a way to ensure that everyone did get a fair hearing and that the extensive concerns that the public have about the provisions that are contained inside this treaty were heard. So I do appreciate that. I also want to acknowledge that in reducing tariffs between South Korea and New Zealand, there will be a benefit in particular to New Zealand exporters. So it will increase the volume of trade and make New Zealand exporters or some New Zealand exporters more competitive than they had been prior to this agreement. A number of speakers have previously spoken and waxed lyrical about those dimensions of this, so I won't spend any more time on that, but I did want to acknowledge that. I would like to speak to some of the concerns of the Green Party and of a number of submitters, which we felt were not sufficiently addressed. They were heard, but not sufficiently responded to, we felt. So in particular, these are around the protocols to the agreement that are around human rights, the environment, labour standards and so on. So none of the agreements that New Zealand has signed up until this point, including this one, contain enforceable and binding agreements in those, or protocols in those agreements, to my knowledge. And we have some questions about, when the government says that these agreements lift human rights standards, that they lift labour standards, that they lift environmental standards. My question is, can they prove it? Can they prove that that, for example, the environmental provisions contained in the ASEAN agreement, have they ever met? Has there ever been any evidence of any of these protocols ever actually having been lived up to in any way? Because we have looked into it and we've been unable to find any where they are. So just the presence of human rights and labour and environmental protocols to these agreements doesn't seem to result in any actual activity. Just because the language is there doesn't actually mean that there is any activity following up on that. So we do have concerns that although this agreement does contain human rights and environmental and labour protocols, that will not actually mean anything because they're non-binding and non-enforceable. And for us to support agreements in the future, we would like to see those kinds of provisions being made binding and enforceable on all parties. The main thing that I'd like to speak about, and a number of other speakers have referred to this previously, is the investor-state dispute settlement mechanisms that are contained inside this agreement. And I do want to acknowledge Phil Goff, who earlier said that this is kind of a stalking horse for the Trans-Pacific Partnership Agreement. There is now widespread public concern about the nature of investor-state dispute settlement mechanisms out there in the public arena. And that does not seem to be getting any lessened. It is in fact increasing that sense of public concern. And I'd just like to say a few things about that. So our history with investor-state dispute settlement mechanisms is fairly narrow and it's fairly recent. So if you take the China free trade agreement, for example, that's been in place for half a dozen years or so, you can say, no, we haven't yet been sued by a corporation under the investor-state dispute settlement mechanisms contained in the China free trade agreement. But the past is not necessarily a guarantor of the future. And the more countries that we enter into these agreements with that contain these provisions, the greater risk we expose ourselves to. While we haven't yet had a case in New Zealand, the thing is that some of our nearest neighbours, such as Australia, have been exposed to these, and We say we here in New Zealand have an excellent legal system. We have a pretty good system of government that means that these kinds of provisions are unlikely to be triggered, but so does Australia, so does Canada, so does the United States. It gets plenty of exercise, that's for sure. And the average cost around the world of even defending oneself without actually, is around something like $9 million US. And so it would be quite easy for a committed corporation to tie up a government, incurring cost even on claims that they know aren't going to come to anything. We also know that as part of the global system that, New Zealand's pretty small fry in the grand scheme of things. But sometimes we are asked to take on responsibilities or we're exposed to situations not because people are necessarily concerned about what goes on here in New Zealand, but because of the example that it shows for the rest of the world. So we know, for example, that large pharmaceutical companies are greatly concerned about Pharmac, not because New Zealand has a particularly large market for pharmaceuticals, but because the Pharmac model is world leading and there are other countries in the world who are looking at Pharmac and considering instituting a similar system in their own countries. And so New Zealand can be exposed to a situation where, because they're worried about the threat of those kinds of systems being instituted in, say, Vietnam or Korea or China or other countries which have much larger markets available, that we may be subject to action kind of as a preventative measure in relation to other markets. We also know that there's a bit of a chilling effect on legislation. So New Zealand has postponed the idea of plain pack cigarette laws because we're waiting to see how the investor-state dispute case between Philip Morris and Australia pans out. We understand that it is unlikely to succeed. They're unlikely to find in favour of Philip Morris, but in the meantime, for the number of years that case is taking, Philip Morris is able to continue extracting profits from the Australian market and also to suppress similar types of legislation occurring in other countries, including here in New Zealand. So sometimes it's not so much about what we do here in New Zealand, but literally because we're part of the international system, that these kinds of mechanisms expose New Zealand to a great deal of risk. And so those are some real practical concerns that we've got, that given the recent history and the short history that we've got in relation to investor-state dispute settlement mechanisms, and given the global history of these kinds of mechanisms, we think that there is a great deal of risk in signing any agreement that includes them. There is also the matter of principle with this. So there's the pragmatic sense about what is the risk, but also what is the principle here? Do we believe that private corporations should have the right to challenge laws passed by a democratic government beyond what already exists in our domestic legal framework here in New Zealand? So we have, a pretty robust, one of the best legal systems in the world. Surely if a company that invests here feels that they have been wronged by the actions of our government, they do actually have recourse to that within the New Zealand court system, rather than relying on or actually bypassing the New Zealand legal system and going to an international arbitration court, which there are many issues to do with in terms of jurisprudence and the quality of those decisions and so on. So for all of those concerns, we do have real concerns about signing up to this particular agreement because it contains these kinds of provisions. And we would like to see trade agreements that encompass the following things: respect for democracy and sovereignty, and that promote good international governance, respect for human rights, labour standards, and promote environmental standards and ecological sustainability, and that promote just and sustainable development, and that those kinds of provisions in agreements would be binding and enforceable. And until our free trade agreements do this, we're not really in a position to be able to support such agreements, and therefore we will be voting against this bill. Thank you, Mr. Speaker.